60 million American workers, from warehouse packers to rideshare drivers, are currently locked inside a legal trap they probably don't even know exists. The trap is buried deep in the fine print of the employment contracts we all sign on our first day. It's called a mandatory arbitration clause. By signing it, you legally forfeit your right to a public trial. If your boss steals your wages or ignores harassment, you cannot sue them in court. You cannot join a class action lawsuit with your coworkers. You have to fight the company completely alone, behind closed doors, in a private arbitration room. This chart reveals the stark reality of those private rooms. The house almost always wins. Employers win 78% of the time in private arbitration. These clauses are meticulously engineered to isolate the individual worker and hide corporate abuse from public view, granting companies near total immunity from the consequences of breaking the law. But 2 days ago, on May 28, 2026, the Supreme Court delivered a ruling that blasted a massive hole in that wall. The legal earthquake started with Angela Brock, a delivery driver whose route involved driving a Wonder Bread truck to local grocery stores. When Brock tried to sue the bakery corporation for unpaid wages, the company pointed to his contract and tried to force him into private arbitration. They argued he was just a local driver who never crossed a state line. Brock's legal team argued something different. He was actually the final link in a massive interstate supply chain. This map tracks exactly how the Supreme Court viewed that argument. In a unanimous 9-0 ruling, the court decided that if a worker transports goods that originally crossed state lines, that worker is exempt from forced arbitration under federal law. That applies even if the driver never leaves their home state. If you are handling the final local leg of a journey, taking goods from a local warehouse to your door, you qualify for the federal exemption. This ruling hands millions of gig economy and last-mile delivery workers a legal sledgehammer. It gives them the immediate power to break out of secret arbitration and drag massive delivery giants into open court to answer for wage theft. While the courts offer a path to restitution, most workers rely on a second, more immediate layer of defense: federal enforcement agencies that actively police corporate behavior. Take the Equal Employment Opportunity Commission. This agency is mandated to investigate claims and process your paperwork if you experience workplace discrimination or harassment. Then you have the National Labor Relations Board, protecting your right to form a union, and the Federal Trade Commission, which stops corporate monopolies from crushing competition and depressing wages. When filing a massive lawsuit is too expensive or complex for a single person, these specific agencies step in. They act as the objective, daily safety net standing between the individual and systemic corporate abuse. This timeline illustrates the 90-year-old precedent, Humphrey's executor. It legally insulated these agencies from the president, ensuring they enforced laws based strictly on facts, detached from politics. That streak ended in 2025, when President Trump fired independent commissioners without cause to remove ideological opponents. Now, a second Supreme Court ruling dropping this very month, Trump versus Slaughter, will determine if those firings were legal. The court will decide if the president has absolute unchecked power to fire and replace agency heads at will. The immediate functional consequence of this is paralysis. Without independent commissioners in their seats, these agencies lose their required voting quorums. Overnight, thousands of discrimination and labor claims instantly stall out, unprocessed. If the Supreme Court rules in favor of the administration, it completely strips these agencies of their historical, mandated objectivity. It transforms objective worker protections into volatile political weapons that can be turned on or off based entirely on election results. We're heading into the summer of 2026, watching two massive forces violently collide: the sudden expansion of gig worker power in the courts, crashing directly into the potential dismantling of federal agency protection. This collision leaves us with three immediate realities. In scenario green, the Supreme Court finds a middle path in Slaughter to preserve agency functionality. Meanwhile, Congress steps up to permanently codify the Flowers Foods arbitration victories into law, giving workers maximum leverage. In scenario yellow, federal agencies are gutted, making your worker rights dependent entirely on your zip code. In scenario red, the administration gains total control, while corporations successfully close the new arbitration loopholes. American labor law is currently in a state of rapid, unpredictable flux. You can no longer passively rely on the assumption that the system will automatically protect you. You need to take defensive action right now. Start by locating your current employment contract or your gig app's terms of service. Read the fine print and find the exact wording of your arbitration clause. If you drive for a delivery app or handle logistics, you can actively leverage the new Flowers Foods interstate commerce exemption to challenge those restrictive clauses today. And if you are sitting on a legitimate workplace discrimination claim, file your paperwork with the EEOC immediately. Do it before the impending slaughter ruling potentially shuts down the agency's ability to process cases. The Supreme Court may be rewriting the rules of leverage from the top down. But the ultimate power to enforce corporate accountability always rests in the hands of the informed, proactive worker.